Thank you. Please be seated. Good morning. We're here for oral argument in case number CV1983, Bridgeman v. Certa. These proceedings are being video and audio recorded and also live streamed now. So we ask counsel to please identify yourselves and your clients at the beginning of your arguments. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we've read the briefs and have discussed this case in conference. Counsel, you may proceed.
Good morning. Flynn Carey and Emma Mark for appellant Mr. Bridgeman. He's present in the gallery. I'm going to reserve 5 minutes. May it please the court, we are not asking the court today to overrule the Nyquist case. The analysis that we've provided of subsection A7 of 28672 is compatible with Nyquist. It answers the questions that are left open in footnote 3. It honors Judge Swan's concurrence in Nyquist. It incorporates Judge McMurdy's analysis of our specific subsection in the Gamzo Lower Court of Appeals opinion. And most importantly, it adheres to Darendal because it preserves a jury trial right which the defendant was entitled to in Arizona pre-statehood. Our analysis of 28672 is that it is in fact 22 different offenses. It is 11 predicate offenses that can be criminalized in 2 ways, either through the showing of a serious physical injury or through the showing of death. Our specific subsection references by incorporation 28794 that a driver exercise due care to avoid colliding with pedestrians. The driver is essentially required to act in a non-negligent manner when operating a vehicle to avoid those types of collisions. Once 794 has been proven, including the proof that there has been negligence in the operation of the vehicle, then the state must only prove death or serious bodily injury, and then it is completed at that point. It is the combination of death plus negligence that creates the jury right that ties to the analysis in Darendal.
So the jury right only applies if there's a death. It's under the same statute that includes both serious physical injury or death. So if there hadn't been a death here, you would agree there's not a jury trial right?
That issue is not squarely here because we're in a different situation. However, what I can say affirmatively is that because of death, that is what gets us to the analysis of what the proper antecedent is for this case, which is involuntary manslaughter. If you look,
the analysis doesn't we don't have to look at each of the elements. We can just say it's this part of the statute that says if death results and there's negligence, then we have the common law antecedent of involuntary manslaughter.
Exactly. There's 22 offenses here, and the legislature cannot lump 22 statutes together, 22 offenses together, and then have it painted with a broad brush.
But it's even more than that if we kind of separate out. This is actually an offense if it just involves serious physical injury. So we're saying there's 25 or whatever.
Yes, there's 22 because there are 11 underlying predicate offenses. There are 11 if you look at it, then the state either proves death or serious bodily injury. So there's 2 different ways that this can be an offense that is prosecutable. And so there's 11 versions of it that have death, 11 versions of it that have serious bodily injury. So essentially, unfortunately, we do have to divide those up. And that's where Nyquist left open some possibilities. Nyquist was an injury case. And so because it was an injury case, the appellant, when challenging the right to a jury trial and saying that they were entitled under Darendal, they could not use involuntary manslaughter because the victim in the case had been injured but not killed. What happened in this case was that the alleged victim was killed. And so we have A7, which has a due care or a negligence requirement. We also have a death. And so this allowed the appellant to seek a jury trial under Darendal because that is the equivalent of involuntary manslaughter. So it's those 2 ingredients together. Now, the issue, though, as well with this I'm not taking the position that the mere existence of death gives a jury trial. And the reason is there are certain offenses, certain predicate offenses that are binaries, which is what I've been calling them. This is noted by Judge Swan in his concurrence in Nyquist. If someone runs a red light, we're not going to analyze, did the person run the red light negligently? Did they exercise due care? Did they do it knowingly? The A1 subsection of 672, which references the running a red light, it's a yes or no, did it happen? If it happened, then the state only need prove further that there was a death or serious bodily injury, and is there a causation element? Did the red light running cause the death or serious bodily injury? The difference is with A7, it is not a binary. The reason due care is there is that there are a variety of reasons that a pedestrian versus car accident occurs. The legislature in 794 built in mens rea because of a recognition that there are a variety of reasons that cars and pedestrians collide. Certainly, driver inattention is one reason, negligence is one reason. But another reason is a pedestrian stepping out suddenly at a time when the vehicle, just by pure physics, does not have the ability to stop. An impaired pedestrian, someone with a very high level of methamphetamine like we have in this situation. Those type of situations, it is not appropriate to make the underlying predicate offense not have a mens rea because you have to make a determination, did the driver exercise due care or not? The issue that we have with the lower court of appeals opinion and the state's defense of it at this level is that it painted 672 with a very broad brush. 672 is a strict liability offense. We are not challenging that. And the footnote 3 of Nyquist specifically says that there is a concern about how do you square strict liability in an offense with an underlying civil predicate that has a mental state. They can be harmonized. The issue is 672 is a backstop. It is to prevent a situation in which new mens rea is added into the statute. For instance, there was a question in Nyquist, do you knowingly have to commit the offense? Nyquist said that 672 itself was strict liability. However, in order to prove 672, you have to prove the civil predicate and you have to prove death or serious bodily injury. So under 794, our statute, our predicate offense, it has built into it mens rea. If the court were to read that mens rea out of it, then it would no longer be requiring the state to prove 794 because that is an inherent element to 794. There's nothing in 672 that says it is removing or deleting mens rea. It simply says that these are the two elements, the offense plus death or serious bodily injury. If there is inherent mens rea in the underlying civil statute, that does have to be honored. Otherwise, we're not following the statute anymore, and we're actually reducing the elements that are required.
Could I go back to Nyquist?
Please.
And I'm just not remembering. It said the common law antecedent offense was operating a motor vehicle so as to endanger any property or individual. But were the facts in that one, the offense was not stopping, running a red light, or running a stop sign?
It was running a stop sign and not using caution before proceeding. The difference with the A5, which is where that case was decided, was the injury. What happened there is it was not a death case. And the problem with...
But the antecedent offense just said operating a motor vehicle so as to endanger an individual.
Correct.
Why wouldn't that include no injury was required and they were entitled to a jury trial under that one?
I do not believe that Nyquist was decided incorrectly. There was no jury trial right there because the court found that the antecedent did not match the underlying offense.
And that's why I apologize. This is just my lack of having tried to square the offenses. But the antecedent offense, I'm just reading from Nyquist, was operating a vehicle so as to endanger any individual.
That's correct.
So if you were entitled to a jury trial under that one.
No, a Nyquist ruled that you were not entitled.
But that under the common law antecedent, if you operated a vehicle so as to endanger an individual. So why why didn't that?
Well,
why shouldn't
I
that have
believe
led
that
to a-
Nyquist did not find that the common law antecedent was substantial match. That was part of the issue.
And
so
what was the difference? That's
the
my question
difference
is-
here is that we have had that case resulted in a death, I believe that the appellants in that case would have used involuntary manslaughter.
And I guess I'm unfairly just asking you to explain the holding in Nyquist. Why
Well,
did
the
that
holding
not
in
line up?
Nyquist was that it's a strict liability offense and that there was not the
strict liability in running a red.
Strict liability in running it, but the issue is not necessarily the strict liability in running because there is a caution element in A5. The problem is that the territorial antecedent that the appellants used was not sufficiently similar to the current offense, whereas in our case, it is nearly identical. And
But that seems pretty similar. You run a red light and harm somebody, you operate them, that's the current offense in Nyquist, then the antecedent, operating a motor vehicle so as to endanger an individual.
Well, the difference is the death component, and that under common law, when there was a negligence, and we've provided you case law, or both case law in English common law and actually the 1901 territorial statutes regarding certain conveyances. When a conveyance was used and that conveyance was operated legally yet negligently, that resulted in death. And it resulted in death. That was jury eligible. The problem in Nyquist was that it was for a different subsection for the A5, and not only was it for a different subsection, but it resulted in injury. So the endangerment component is the closest antecedent that could be found. It would have been completely inappropriate for appellants to argue involuntary manslaughter as the antecedent in a case where there was not death. The reality is that the legislature has made the decision to make 28672 a cross-reference, an incorporation by reference statute. And the analysis has to be on a case-by-case basis. Nyquist specifically left open two things. It left open a case, it specifically encouraged a case that was properly raised and might be dispositive. And in this case, the death plus negligence equation that was not present in Nyquist is dispositive. The court can preserve Nyquist, and there's nothing that the court needs to do to change Nyquist at this point. Nyquist stands very much for the proposition that when you have an injury case, the closest antecedent may be this idea of endangerment. But endangerment is not death. Endangerment is putting people at risk. Our case is what happens when the other half of the statute is utilized, the death part of the statute. Ours is compatible with Nyquist in the sense that Nyquist can stand for injury, it can stand for the A5, ours is the A7, and it can stand for what happens in a death situation where there is a requirement of mens rea. For instance, if the A1, the just pure running a stoplight was litigated before the court, under Nyquist or under our case, there'd be no jury trial for that because we're simply in a binary state. Did the actual traffic violation happen?
Okay, counsel, let me stop you for just a moment because you've indicated you'd like to reserve 5 minutes
Yes.
for rebuttal, and we would like to have at least some discussion regarding the jurisdictional issue.
Of course.
That we requested.
Does Your Honor have a question specifically?
Well, specifically, do we have appellate jurisdiction?
You absolutely have appellate jurisdiction.
All right, tell us why.
Rule 8A special action specifically says that special action, a decision of the Superior Court in a special action shall be reviewed by appeal. You have jurisdiction statutorily, first of all, because of the 2101, that an appeal may be taken to the Court of Appeals from the Superior Court from a final judgment entered in a special proceeding commenced in Superior Court or brought into Superior Court from another court. Finally, under 120-21, appellate jurisdiction proceedings originating or permitted by law to be appealed from the Superior Court. Those three together function to give you jurisdiction. The issue is that the state has attempted to adopt this idea that if special action jurisdiction is granted, then it results in having to further special action, whereas if it's denied, it's an appeal. There's no basis in law for that. The reality is Coffey v. Ryan Toohill specifically says special actions are their own proceedings. They set separate and apart from the underlying dispute. So if we have this compact Superior Court civil dispute that is resolved with a final judgment as it is here, the tool or the vehicle by which to get us to Court of Appeals is an appeal. Bayardi did not decide this issue. I was the attorney on Bayardi. And what happened in Bayardi is there was a lower court of appeals special action. Judge McLennan granted relief for the state. We appealed. The other side agreed it was an appellate issue. The court did not rule on the issue. It utilized special action jurisdiction and said, well, this is of statewide importance, whether there's a specific defense that's affirmative defense or justification, it's statewide importance, but it used special action. Chopra specifically decided that it was appellate, and if you compare Judge Thompson's concurrence in Bayardi with Chopra, they're almost identical, because Judge Thompson, during oral argument and then afterwards in his concurrence, specifically hit on the issue that Your Honor is asking about. He specifically indicated the question about jurisdiction. And Chopra ultimately adopted that. The idea is, just briefly on this jurisdictional issue, if a special action in the Superior Court, the difference, it should always go up on appeal. The question is what the court does with it. If the special action is granted, or jurisdiction is granted and the special action is ruled on, then the court should review that appeal with eyes towards de novo legal review. If jurisdiction is denied, as in Chopra, then it's simply an analysis on appeal of whether or not the lower court of appeals, the Superior Court, properly denied jurisdiction, and it's an abuse of discretion analysis. So what I would focus the court on is the proper vehicle once a self-contained special action, which is civil in nature according to Coffey v. Ryan Toohill, once that is a concluded piece of litigation at the Superior Court, there's nothing further for the Superior Court to do. It is a proper vehicle for appeal. In this case, we have no basis to try to argue that it needs to be special action because we sought and obtained stays at the trial court level so that we could bring this up. We have our remedy, and we're utilizing it through the appeal process. If there's not further questions, I'd like to reserve my time.
Thank you.
Thank you.
Thank you. May it please the court, counsel. I'm Robert Prather with the Maricopa County Attorney's Office, appearing on behalf of respondent, appellee, and real party in interest, state of Arizona. While the court questions its jurisdiction or how it can obtain jurisdiction in this matter, if we read the cases the court wanted us to address in the supplemental briefing and the Nyquist case and Robinson v. Kay, we see that the previous decisions, the court has expressed the opinion that if there's any doubt of jurisdiction, the court should accept it as special action jurisdiction. And the fact that the court is now questioning its jurisdiction shows that there is doubt as to what type of jurisdiction it should take. And therefore, we think the previous cases and the established case law show that when in doubt, to exercise special action jurisdiction. So we're asking the court to exercise jurisdiction under that. In doing so, we can look to the Nyquist case. The Nyquist case mentioned that in footnote 2, that it took special action jurisdiction. And speaking of the Nyquist case, petitioner appellant says he doesn't want this court to overrule it or to reverse itself in that case, but what he's asking the court to do is to hollow it out so much that it's practically meaningless. Or in the alternative, what's going to happen is out of the 22 offenses that he's identified, 11 may have the same conclusion that there is no right to a jury trial, but the other 11 are going to have to be examined independently, and the results can be highly different.
What's wrong with that if there is, if you put death together with negligence?
Well,
why isn't that involuntary manslaughter as the common law antecedent?
Well, the involuntary manslaughter is defined in the, I believe the pronunciation is I-tinge. I'm sorry if I don't know how to pronounce the case, the territorial case. It defined involuntary manslaughter as a death, which was from the lack of due care and circumspection. It added an element of circumspection to involuntary manslaughter.
What does that add to lack of due care?
I think circumspection
what does circumspection mean?
That implies that an ordinary reasonable person may identify a risk and proceed accordingly without regard to that risk, whereas due care just requires an action on the individual without being aware or acknowledging that there might be at risk involved in the action.
So you're saying there's an extra element in the in involuntary manslaughter that's not present here? Circumspection is the difference?
Yes, sir. I think circumspection,
Are due care and circumspection both mens rea elements? And so in that case, there'd be two different mens rea elements in the same offense?
well, if we look at the case, pardon me for a moment. I'm not sure that would go to two different mens rea because
Okay.
uh,
Is
the-
one of those a mens rea element?
I would say the lack of circumspection would create the mens rea, and the fact that it requires that someone identify a risk and act with disregarding that risk or assuming responsibility for that risk, whereas due care is sort of a default position of being a sentient adult human being, that you take due care in your actions and your behavior and try not to exceed that. Whereas by requiring circumspection, that court is acknowledging that the involuntary manslaughter required a higher level of irresponsibility, perhaps, rather than normal, reasonable behavior. I think part of that we can see, I think in Nyquist, this court sort of implicitly recognized that in its analysis of 672 and making it a strict liability offense. It went through pretty thoroughly that the legislator intended 672 to be strict liability. It mentioned the fact that it changed from a civil violation to a criminal violation.
That's running a red light or going through a stop sign. Isn't that different than
Well, in
not
Nyquist,
exercising due care?
the court said the defendant there did stop. He stopped at a stop sign, then proceeded to make a left-hand turn. And when he made that turn, he hit the scooter. So he did not make a civil traffic violation. He did, according to those facts, he did come to a complete stop and then made his left-hand turn. So I believe that shows that that furthers the proposition that the court and the legislator intended this to be strict liability offenses. And if you look at the offenses listed under 672, they all speak in different language about what a person is required to do. For instance, in A2 regards traffic lanes, and it requires the driver to ascertain that it can be done safely. That seems to be an imposition of a duty onto the driver in that one. And A4, left-hand turn at the intersection, the driver has to evaluate the situation to see if it constitutes a hazard. In A5, in entering an intersection, the driver must proceed with caution.
But here we're talking about, we're just talking about negligence and a death. Is it you?
Well,
You would agree
negligence-
with the instant offense?
Well, negligence, I think, is an entirely different standard. Negligence, like circumspection, requires that they appreciate the completed consequences of your actions, that you know that you're acting in a certain way and there may be dangerous or legal consequences to your actions. Whereas just performing or under strict liability, you're just doing what you're required to do. And I think
You think exercising due care is different than negligence?
well, yes, especially in A7, where if there wasn't a result of serious injury or death, there wouldn't even be a traffic citation in that matter. Police don't write citations for violations under 28794 unless there is a injury or death. I think that kind of distinguishes it, or is something that must be considered in the analysis. Also, when we're looking at the cases,
But you're saying this is exercising due care requires more than the circumspection in that you agree that if there's negligence and circumspection and a death, there's a common law antecedent involuntary manslaughter. So how does this not line up with due care and causing a death?
Well, I would define due care as probably the care an ordinary reasonable person would use in performing whatever action they're performing, whereas negligence would require,
Isn't that, oh, go ahead.
well, negligence requires a degree of care in protecting others from a foreseeable circumstance.
How are those appreciably different?
I think it's a matter of degree. As I mentioned, in performing an act, any act, someone would use due care, but in being held negligent in an act, a person is ignoring or disregarding what could be a foreseeable harm or a risk involved in the action. So I think it can be distinguished that way. And
So you would say if someone's convicted under the current statute, the state has not shown that they were negligent?
well, if you're referring to that in the civil context, I would have to defer to a civil attorney on that one.
I'm just trying to figure out how this is different from this common law antecedent of negligence plus circumspection. And I apologize, I haven't focused
Well-
on that word, but they seem awfully close to me. I'm struggling with the distinction between due care and negligence plus circumspection. We agree that death, those line up.
Yes.
And so we're left with, does the failure to exercise due care equate with negligence plus circumspection?
Well, when we look at the guidance from this court in the Durendal case about equating the common law antecedents, it mentions that they have to share similar character. And involuntary manslaughter and situation at question here aren't really of necessarily the same character.
We're taking death, there's death in both of them, so all we're focused on is what's different between negligence plus circumspection and failing to exercise due care.
Well, due care, I think, can be defined as just the care an ordinary reasonable person would always use, whereas
And
someone
negligence
performing
isn't failing to
negligence
act the way a reasonable person would act?
is either disregarding an appreciable risk that a reasonable person would acknowledge in the situation and disregarding it, or not taking a degree of care to protect others from that foreseeable risk. I think negligence.
I understand that that you use some different words there, but I'm still not seeing how they're substantively different.
Let me see if I can explain it. I think if we were to look at, for instance, in Nyquist, the defendant there did come to the stop, so he did not violate or run a stop sign. Running a stop sign at night would rise to the level of negligence. Stopping and then proceeding without particularly looking at there was a pedestrian there might be a lower level of exercising due care. So I think it depends on the analysis of the situation and the actions of the defendant. And also, if this court does decide to exercise its special action jurisdiction as the defendant acknowledged, we'd ask that this court find that rule consistent with the Nyquist decision. There's nothing that distinguishes Nyquist from this current case other than particular semantics, which the court in Nyquist was very clear. It answered the question, does 672 does 672 qualify for a jury trial? And this court answered, no, offenses charged under 672 do not qualify for a jury trial. Thank you.
Thank you, Counsel.
If I may, Judge Catani, I wanted to close the loop on your question about Nyquist and the antecedent offense. Paragraph 17 is of the opinion. What happened there is they argued that operating a motor vehicle to endanger property or person or individuals. The court said that they were incorrect. A person need not actually cause serious physical injury or death to another to be liable under the common law offense. That's why that antecedent didn't work, was because in Nyquist, the antecedent that they chose, I think probably because they had to, because there was not a death, did not necessarily require injury or death. And so there wasn't a substantial
But
hit.
you were entitled to a jury trial for a less serious offense. It seems I'm still a little bit puzzled. A person not, I'm reading from the same paragraph. A
Yeah.
person need not actually cause serious physical injury or death to another to be liable under the common law offense. So you were entitled to a jury trial even though you didn't have to cause as much harm as you're causing under the statute. So why wouldn't you have been entitled to a jury trial under the rationale we're discussing?
The antecedents didn't match. The statute that they had was the 670. We were dealing in Nyquist with 672, which had to have serious bodily injury or
But
death.
my question is, if you were entitled to it for a less serious offense where everything matches up, why wouldn't you have been entitled to a?
Because the gradation of the offense doesn't matter if under Darendal there is a substantially similar match. There were a variety of reasons that we gave jury trials to people. For instance, disorderly conduct is jury trial eligible under Arizona law because of a territorial equivalent. This is more serious than disorderly conduct. That's not the necessary analysis. The analysis is can we locate a proper antecedent offense under territorial times? I mean, that.
Well, and I agree with that.
And-
As you can tell, the elements seem to line up with involuntary manslaughter, but I'm struggling with how to distinguish Nyquist when it does line up. Endangering someone is kind of a subset of actually injuring them.
Well, you can endanger people in lots of ways without actually injuring them. And the focus is 672 adds to that civil offense death or serious bodily injury. So it's the presence of the death or serious bodily injury. Had the person actually been killed, we would have been in involuntary manslaughter territory. Had the person just been injured, as in Nyquist, there's just simply not an antecedent. And so the issue is that these will not always line up perfectly. Darendal does not require identical, it requires substantially similar. And with the combination of conveyance law that we've provided you from England, Ireland, and from 1901 and 1909, the actual underlying territorial statutes, those all allow death and negligence to require a jury trial. Just very briefly, we are not asking you to hollow out Nyquist. We're asking you to complete the puzzle of Nyquist by filling in the gaps that were recognized under footnote 3, which is how do we square strict liability of the overlying statute with the underlying predicate offense.
I know you're running out of time, but if the offense in Nyquist was proceeding after having stopped, it's kind of different. Isn't that more of a negligence?
Well, it involves caution. So Nyquist, had Nyquist been a death case, I think the appellants could have argued involuntary manslaughter because, again, there were words of negligence in A5, just like there are in A7. I think the instructive part of this is under Judge Swan's concurrence where he references A1. That is what I've been calling a binary case. It happens or it doesn't happen. And so I think what you can do to close the loop on this is if you adopt an opinion that negligence plus death, a civil predicate that has a negligence or mens rea component plus a death is jury eligible. A binary case of yes, no, did it happen, did it not happen, without inquiry into the defendant's state of mind or specific actions is a non-jury eligible. That's, I think,
Counsel,
the framework.
let me stop you for a second because you ran out of time about a minute ago.
Very well.
Do you have any additional questions, Judge?
No, thank you.
Any other? No? All right,
Thank
thank
you,
you
Judge.
very much. Counsel, we thank you both for your preparation and your arguments. This matter is now under advisement. We will issue a written order in due course. We'll take a brief recess at this time to set up the courtroom for the next argument. Thank you.